All right, let's jump right in. We're going to tackle one of the most interesting corners of criminal law, the mistake defense. The big question for today is pretty simple. When can a defendant legitimately say, I didn't know, and have it actually work as a legal defense? We're going to break down exactly how the courts figure this out.
So let's put you in the hot seat. Imagine you broke the law, but it was a complete accident, a total mistake. Does that make you a criminal? Well, as you can probably guess, the answer isn't a simple yes or no. It really depends. And the law has a very specific framework for figuring that out, which is exactly what we're going to master today.
To get to that answer, we need a structure. We can't just guess. So we're going to start with the absolute foundational rule, the core principle that kicks off every single analysis of a mistake defense. From here, everything else will branch out.
And here it is. This is the whole ballgame right here. A mistake is only a defense if it cancels out the specific mens rea, that's the guilty mind or criminal intent, that the law requires for that particular crime. So it's not some magic get-out-of-jail-free card. It's an argument that says, hey, I couldn't have had the necessary criminal intent because my understanding of the situation was wrong. The entire analysis really hinges on that required mental state.
Okay, so our analysis begins at a critical fork in the road. The very first thing we have to do is classify the defendant's mistake. Was it a mistake about a fact, or was it a mistake about the law itself?
This slide lays it out perfectly. On the left, you have a mistake of fact. This is about misunderstanding the physical circumstances, like genuinely believing a real gun is a toy or that it's unloaded. On the right, you have a mistake of law. This is just plain ignorance of the rulebook. I had no idea that was illegal. As we're about to see, the legal system treats these two types of mistakes completely differently.
Let's start with a mistake of fact. To figure out if this kind of mistake is a valid defense, we have to look straight at the statute and ask one question. What was the required mens rea? What level of intent does the prosecutor have to prove? Was it purpose, knowledge, recklessness, or just negligence? That mental state is the absolute key.
Okay, this chart right here is the engine of our analysis for any mistake of fact. Seriously, screenshot this. If a crime requires purpose or knowledge, any honestly held mistake works as a defense, even if it seems totally unreasonable to the rest of us. Now look at that recklessness row. A mistake is a defense if it prevented you from consciously disregarding a risk. Think about the classic case State versus Sexton. If a defendant genuinely believes a gun is unloaded, he can't be consciously disregarding the risk of it firing, right? His mistake negates recklessness. But then look at the last row, negligence. Here the standard flips. The mistake has to be reasonable. Would a regular, prudent person have made the same error?
All right, now we're heading down that other path, mistake of law. And for this one, the general rule is one of the most famous and, frankly, one of the harshest maximums in the entire legal system. There it is. Ignorance of the law is no excuse. The entire system is built on this powerful, maybe even necessary fiction that we are all presumed to know the law. And you can see why, right? If I didn't know was a valid excuse, it would actually encourage people not to learn the rules, and it would clog the courts with endless, impossible-to-prove claims of ignorance. Now, it's really important to get this distinction right. This super strict rule applies to mistakes about the penal law. That's the criminal statute you're accused of breaking. If you make a mistake about some other non-criminal law, what we sometimes call a collateral law, that's usually analyzed just like a mistake of fact. But for this general rule, we're focused on being ignorant of the crime itself.
To see just how tough this rule is, let's look at the classic case, People v. Marrero. So the facts are this. You have a federal corrections officer, he reads a New York gun statute, and he interprets it to mean that he qualifies as a peace officer who is exempt from the weapons law. He genuinely believes he's allowed to carry a handgun, but he's wrong. So the issue for the court was, could his personal, good faith misreading of the law excuse him?
And the court's answer was a huge, emphatic no. The court held that Marrero's private misinterpretation of the statute was no defense at all. Their logic was simple. Ignorance or mistake about what the criminal law says is not an excuse, period. This case is probably the best example you'll find of just how unforgiving this rule really is.
But the rule isn't totally absolute. Just when you think there's no way out, the law does recognize a few very, very narrow exceptions. And they all boil down to one idea. The mistake happened because the government itself messed up.
So here they are. The key to all of these exceptions is the source of the bad information. As you can see, a defense is allowed if you were relying on an official government source that turned out to be wrong. Maybe the law was never published, or you relied on a court case that got overturned, Or you got an official interpretation from someone like the Attorney General. The mistake has to trace directly back to the government.
And this is a hugely important point to remember. What doesn't qualify? Getting bad advice from your own private attorney. That is not a defense. As far as the law is concerned, if your lawyer gives you bad advice, that's on you, not the government.
Okay, so we've covered a lot of ground. Let's put this all together into our key takeaway. This is the step-by-step checklist, the exam attack plan you should use for any mistake defense problem. It's the same process a court would follow.
Let's walk through this real quick. 1 and 2. Always start by breaking down the crime's elements and checking if it's a strict liability offense. If it is, mistake is irrelevant and you're done. 3. Figure out the specific mens rea. 4 and 5. Identify the mistake and classify it. This is our big fork in the road. Is it fact or law? Step 6 is the test. If it's a mistake of fact, does it negate the required mens rea based on our chart? If it's a mistake of law, does it fit one of those tiny official reliance exceptions? And finally, you wrap it all up and conclude, can the prosecution prove its case?
So now you have the framework. The next time you're reading a news story or analyzing a case where the defendant claims, "I just didn't know," you can apply this exact process. You can ask, was it a mistake of fact or law? What was the required mens rea? Does the mistake actually negate that specific mental state? This is how you go from just knowing the rules to actually thinking like a legal analyst.